So at this time, I do call the first case, and parties may come to the council's table and get set up, and then we will have appellant make their appearance at the podium. This is Melissa Heinzman versus State of Kansas, appellee.
May I please call Your Honor David Miller?
Oh, it's all right.
I'm sorry.
Are you ready to start your argument?
I am.
You can come to the podium.
Okay. Excuse me. Good morning, Your Honors. David Miller for the appellant, Melissa Heinzman. And I would request of the court 5 minutes for rebuttal.
5 minutes is granted.
Thank you, Your Honor. This is an appeal from a denial of a KSA 60-1507 petition. The underlying issue was whether Ms. Heinzman's plea was made in a knowing and voluntary fashion due to ineffective assistance of counsel. And the evidence below, we believe, certainly indicated that her plea was not made in a knowing and voluntary fashion. The first, obviously, excuse me, with the Strickland standard, we are dealing with the two prongs, deficient performance and prejudice. For the deficient performance prong, we've cited to the United States Supreme Court's decision in Strickland and the progeny of Strickland in many cases flowing from there. The court has indicated that they often look to the ABA guidelines and standards for what is reasonably appropriate attorney conduct. At least that's the guidepost that they look to, and at least the beginning point. And we cited to the criminal defense standards, specifically the ABA criminal defense standards with regard to how counsel, or what counsel should do in a case where ultimately the case ends up in a plea of guilty. And those standards really very emphatically say that, excuse me, the counsel cannot advise a defendant to plead guilty until there has been a thorough review of the law, potential defenses, as well as going over the evidence with the client. And so that we suggest that is the standard, at least for the deficient performance prong in this particular case. And Mr. Landis, Attorney Landis, was the attorney below. Ms. Heinzman initially, I think, had one attorney who met with her one time, and then he left. Mr. Landis took over. I believe his name, the first attorney was Byfield. But Mr. Landis was the attorney that represented Ms. Heinzman at the plea hearing. So she was charged with the knowing ag battery of a law enforcement officer. I'm sure the court's aware, based on the briefs, of the facts of the case, but basically Ms. Heinzman was stopped by law enforcement. The deputy approached. Ms. Heinzman drove off, and unfortunately the deputy was either got her foot caught in the wheel and apparently was drugged.
So when she was stopped stopped by an officer who was in a police uniform, is that correct?
That is correct.
And in a patrol car assigned to that police officer?
I believe that's true.
So anybody's being stopped would know it's a police officer that was coming?
Yes, I'd agree. Ms. Heinzman was also testified, and there was evidence below that at the time she was, I think, fairly heavily intoxicated, either under the influence of methamphetamine and alcohol. And so one of the issues that we've raised, and we cited to the Tucker case, I know it's an unpublished opinion, and I asked Mr. Landis if he was familiar with that case. And I cited it because it's factually, no two cases are identical, but it's pretty close to what we have here. And Tucker, in that case, said that if there's evidence of recklessness, that lesser included offenses of reckless battery and reckless ag battery are both legally and factually, or can be legally and factually appropriate in those types of cases. Again, in Tucker, similar thing. Approached by stopped by law enforcement, drove off. The officer was injured.
But counsel, didn't Tucker really deal with the failure to give a jury instruction on a lesser included charge?
That's true.
Do you
yes.
have any cases that would deal with this situation where I understand your position is a failure to discuss potentially lesser included charges being sufficient to invalidate the knowing and voluntary element of a plea?
I don't have any particular cases in Kansas that I've cited. And I agree, Tucker doesn't stand for that proposition. I think the reason that I asked Mr. Landis below about Tucker was just to see what kind of research that he had done for this particular kind of charge, and then whether he explained that if we go to trial, because of these facts, we have the potential for lesser included offenses. And so that's why I cited Tucker. Do I have a case directly saying that in Kansas? No. But I do think the ABA guidelines would, again, as I indicated, as I argued, would set the standard at least that a defense attorney should investigate the law and inform his client.
So you would agree with me that, let's put that scenario in play. He tells Ms. Heinzman, if we go to trial, there's a possibility that the judge will instruct on a lesser on reckless. But Mr. Miller, you and I know district courts do not always instruct on the lesser if they don't see that. So as an attorney, would that be wise to tell her there's lessers, but we don't know if you'll get them or not at the jury trial? I mean, it's not a guarantee that all things are gonna play out, looking at it now.
I agree, and I think, but that discussion I think has to be had with your client, is that there are potential lesser included offenses that are in play here based on the facts of this case, legally and factually appropriate. We may or we may not get it, but certainly they're available, and if we go and the facts arise during the jury trial, I will request them. But at least the client should have the opportunity of weighing that in the decision of whether or not to plead guilty. And in this case, she did not have that opportunity because Mr. Landis testified below on numerous occasions that he couldn't remember if he ever discussed defenses or lesser included offenses with Ms. Heinzman, and Ms. Heinzman actually testified he did not. I mean,
Well, counsel, didn't he testify? He doesn't remember specifically, but generally, he said, my practice in general is to research the law. He said, I don't remember specifically looking at Tucker, but, I probably would have. And my practice is generally to talk about these lesser included. And he admitted he knew that she claimed that she didn't realize that she had run over the officer, or that the officer, I believe, was drugged by her vehicle. And so, does that not make a difference? I mean, we've got a little bit of equivocation at least. It's not maybe as cut and dried as I never talked to her about this, or I don't think I did, but I probably would have.
well, again, I'm not sure that would meet the standard of what is reasonable for an attorney. Also, I think there is case law, I'm not sure that I cited in the brief, but there is published opinions, and I'm sorry, I can't name them right off the top of my head, but which basically say a defense attorney's inability to remember whether they gave advice or whether they didn't give advice, that is not strategic, or that doesn't meet the level of reasonableness under the Strickland standard. So,
Well, if we have an attorney who, he admitted he's defended these types of cases before, specifically the ag battery charge, he's done this several times, and he talks about his general practice with how he handles those cases, why can't the judge accept that as credible testimony, at least in weighing the two versions from the client and the attorney?
well, certainly, yes, the judge can weigh the credibility. I did make an argument about the manner in which the district court weighed the credibility here. I know this court can't weigh credibility. I understand that. But I think that this court can look at how the judge below judged credibility and whether that standard was appropriate. One, he said, I believe Mr. Landis because Ms. Heinzman was using drugs. Well, there's zero evidence that Ms. Heinzman was using drugs while she was having these conversations in the jail with Mr. Landis.
Well, counsel,
And-
the judge didn't say, I didn't believe her because she was using under the influence of drugs at the time of the hearing. I mean, it's certainly possible that, you know, a past history of drug use like she had would affect your memory. I mean, we've got case law on that.
Right, but I think the drug issue goes to, was she under the influence at the relevant time period that we're talking about, i.e. her discussions with Mr. Landis and/or at the time of the 1507 hearing?
What's your
which is-
basis for that?
I'm sorry?
What's your basis for that claim?
Well, I mean, I've cited the case, looks like I'm running out of time.
I was going to tell you, I want you to be able to answer the judge's questions, and I want our panel to be able to ask you questions. So you're not going to lose your rebuttal time, so please continue.
Okay. If I could just briefly look at the case I cited.
Is it Osby? I think you talked about Osby.
Osby,
Yeah.
yes, sorry. So State versus Osby says, to the extent it shows the witness was under the influence of drugs at the time of the occurrences, as to which the witness testifies, or at the time of trial. I get it, at the time of the event, she was under the influence of drugs. But I think the relevant occurrences here are, one, the time that she was having these discussions with Mr. Landis, and the evidence is that she had been in drug treatment and was really starting her life over again during that time period. So there's no evidence of that, or at the trial or at the 1507, there's no evidence of that. I cited Osby for that proposition. One of the other issues that the judge used to weigh credibility was, well, Mr. Landis is an officer of the court, and he has a duty of candor to the court. I get that. That's a rule of ethics. But as far as weighing credibility, especially in the context of an ineffective assistance claim, when the attorney is essentially defending himself, it's almost like a presumption that he's telling the truth because of this rule of ethics.
But counsel, again, the judge made the comment that yes, officers of the court, generally I can trust them, and I've also seen no evidence that he was lying, correct? I mean, the judge went on to say, nobody showed me that he's lying. It's not just I'm taking the attorney's word at face value. I'm saying maybe I start from there, but also, as with any witness, nobody's impeached their credibility. Nobody's shown me an inconsistent statement, unlike Ms. Heinzman, who'd been impeached several times. I mean, at least when you look at it in context, it seems like the judge is saying, okay, with Heinzman, her testimony is impeached several times. When she would say, oh, they only visited me 2 or 3 times, and then the prosecutor would say, well, actually, let's look at the jail visits. And then the judge was saying, but with the attorney, we don't have any of those instances. So
Well,
I'm looking, that's how I'm comparing them, correct?
and I understand that. There were inconsistencies, though, in Mr. Landis's testimony, because initially on his initial direct examination, he denied that or couldn't remember that he even showed the injury reports and the medical reports of the deputy, and reaffirmed that on cross. And then when the importance of that sort of was coming out, then on redirect, he changed his testimony and said, oh yes, I do remember, I went over that with her. In direct contradiction to what Ms. Heinzman said, that he basically never went over the discovery with her at all, or to any great extent. So there were certainly inconsistencies in Mr. Landis's testimony. I agree, you can't judge the credibility. I just suggest that the drug issue and the duty of candor are not appropriate measures for judging credibility. I see I'm out of time.
Did
so-
you want to give us a conclusion, or is there anything you want
Yes,
to add?
for all of the reasons, and I didn't get to all of them today, but all the reasons that we set forth in our brief, We believe that Mr. Land has performed deficient performance under the Strickland standard. As far as prejudice in this context is there a reasonable probability Ms. Heinzman would have declined to enter the plea and go to trial? She testified, had I known of these lesser includeds, had I known of various defenses, had I known of the evidence, she didn't have the discovery.
And you would agree with me, she wouldn't get the discovery because defense attorneys do not give discovery usually to their clients who are sitting in jail, because the discovery gets lost and all of a sudden you have the possibility of jailhouse informant using that discovery against them. So as a practice, most defense attorneys do not give the discovery, but what they do is they go over the discovery with them. Is that right?
I think, well, maybe I'm out of the realm of most defense attorneys, but we redact discovery as required by the local rules, and certainly do, now we can't provide the videos, of course, but discovery is given often on disc to clients in the Sedgwick County Jail. They ask for opportunity to go and look at it.
So that's that's not something that could be lost. In other words,
That's
my example was paperwork that somebody can get a hold of and used against your client.
That's correct.
These don't put your client at risk.
That's certainly a possibility. But I think there is a way, and there is a way.
Sure, that
that
makes
they can
sense.
view the discovery without.
Okay, good. That's good to hear, though, because you always wonder.
I'm sorry, I would ask that the court reverse the court below
Okay, thank you.
and allow Ms. Heinzman to withdraw her plea.
Thank you. Counsel, you have 15 minutes.
Thank you. May it please the court, Assistant District Attorney Chelsea Anderson on behalf of the state of Kansas. I want to first address some of the issues that were just discussed by Mr. Miller and the panel. We'll start in reverse order. The discovery issue, as Judge Pickering, you pointed out, it is true that a number of attorneys do not hand over copies, and pursuant to KSA 223212, she's not entitled to her own copy of discovery. The testimony at the hearing was that counsel had received and reviewed the evidence in its entirety and had discussed his evaluation of the discovery with her prior to her plea. That's all that is required. As to the credibility thing, I think Judge Klein mentioned that there were inconsistencies with her statement, and there was a claim specifically that she said he'd never gone over discovery. He visited her 8 times, and some of those were over an hour, as the inmate jail log pointed out and was gone over at the evidentiary hearing. I find it very hard to believe that none of those were discussing discovery and the facts of the case. It's the state's position that the movement has not established ineffective assistance of counsel as to the discovery or any of the claims. Moving to the possible defenses and the lessers, I would note first that as far as the defenses go, we're using that term kind of broadly here. There's been no identification of affirmative defenses that would apply. Below there was discussion of the voluntary intoxication, but that was not brought on appeal, so that was waived or abandoned. So what we're really dealing with is defense theories of the case, and maybe being able to nitpick at the culpable mental state and the degree of the injury. And there's no case law that discusses that in particular, but our Supreme Court has said that it cannot be the law that failing to inform the defendant of every possible defense, no matter how specious, constitutes representation so far below the acceptable standard that it would be manifest injustice not to allow a withdrawal of the plea.
But counsel, I don't think that their argument is quite that broad, is it? I mean, they're not talking about every possible defense. They're talking about lesser included charges to these particular charges. And attacking elements of these particular charges and how we would show the state can't prove their case. I mean,
Yes.
they don't have to show they didn't, it doesn't have to be an affirmative defense, first of all, correct?
I
I
don't
mean,
know.
wouldn't
I
you
mean,
still, wouldn't you expect if you're gonna have a knowing plea, you would at least have some discussion about if we went to trial, here's our potential defenses to the case, which could include showing how the state can't prove their case?
Certainly, I think that would be something that would be gone over. I'm just pointing out the fact that there is case law that discusses affirmative defenses and the need to go over those. Just recently, the Grant case came down. That was an applicable statutory defense that wasn't discussed, whereas here, I guess I'm just pointing out we're using the term defenses kind of broadly. But I would
And I guess
also,
I'm trying to drill down on why does that matter?
well, I would note that in addition to the fact that you don't have to go over every possible defense, I would note that over and over, the statement, in fact, just now, the statement was potential for lesser included, potential defenses. Well, our Supreme Court has also said that where a defendant pleads guilty, to show prejudice for a claim that an attorney failed to advise of a possible defense as well as possible lessers, two different cases, there must be some showing that the defense or the lesser would likely be applicable or would be successful at trial. And we don't have that here. We don't have that showing here.
Well, we have the
There's-
Tucker case that helps with the potential for the inclusion of the lesser, correct?
Potentially, but also, as I noted in my brief, it's hard to believe that a lesser would be factually appropriate here, because at the evidentiary hearing alone, she testified, she being the defendant, movement, testified to the elements of the crime. The elements of the aggravated battery of a law enforcement officer are that she knowingly caused bodily harm, not great bodily harm, just bodily harm with a motor vehicle to a properly uniformed or identified law enforcement officer. Judge Pickering, you mentioned earlier, asked him specifically whether she knew that it was law enforcement, and she did, and she testified consistent with that at the evidentiary hearing, saying that an officer got in behind her, followed her from Derby into Wichita, turned on their lights to effectuate a stop. She does stop. Then when she's trying to be identified by the law enforcement officer, she freaks out, and she tries to get her keys back in the car, and obviously the deputy is standing right there for knowing. It doesn't require that she's aware that an injury resulted. It's that she has to be aware that her conduct was reasonably certain to cause the result. Well, when a deputy is standing right next to your vehicle and possibly inside your window trying to fight with you over the keys, certainly if you gun it, taken off, then of course you're reasonably certain to cause some injury, and that's what we have here. So I agree with the district court's view that it's unlikely a lesser would have been factually appropriate in
But
this case.
when the district court made that statement, wasn't that statement directed to the great bodily harm issue and not the mental state? I mean, the district court didn't talk about the knowing and reckless issue. He was talking about bodily harm. Doesn't matter if it was fractured or broken, we're still hurt.
There was some of that discussion, yes, but I do recall a specific back and forth where it was noted that, yes, this only requires bodily harm. But I guess either way, I still don't think that the movement has established that a lesser would have been factually and legally appropriate. So first, I don't think he's established that counsel never went over any of this with her, but even if he had, I don't believe we've got prejudice established, and he must establish both, or she must establish both. I wanted to quickly,
So your point is, Unifi had counseled her, and they did go to trial, and they do request the lesser, and the lesser is given to them of reckless ag battery, because she does have substantial injuries. Although they label as a fracture, the jury still may convict on knowingly.
Certainly. I think it's likely, considering the facts that we have in this case, as well as the culpable mental state only requiring that she be aware that her conduct was reasonably certain to cause a result. Additionally, I understand the Tucker case, but I'm a little confused because there is no reckless ag battery of a law enforcement officer. So you'd have to get all the way down to reckless battery. So that would go to whether it's great bodily harm, I suppose, but.
But what about count two?
As
I mean,
to,
my understanding is count two was, didn't require great bodily harm.
count two would have required great bodily harm. Count two was leaving the scene of a injury accident, and that did require great bodily harm. To that point, I would note, though, again, there appears to be confusion on whether a fracture and a break are the same thing, and medically they are.
Can you help me out? In volume 1 of the journal entry of her plea, the district court judge orders $33,000. It looks like Wichita, Sedgwick County Risk Management of $33,322.83. That is to take care of the injuries that was that to take care of her medical bills?
I assume so, I'm sorry.
Okay,
I
because
don't know
at,
for sure.
at the hearing, when they do order the restitution, they say she was injured, she went to the hospital. So,
She did have a surgery. I mean, that's, I guess, outside of some of the record below, so, but I
And-
believe it was in the probable cause affidavit that there was a surgery.
and so you don't know who Sedgwick County Risk Management is? That could be a surgery unit or,
I'm not 100%
Okay.
sure.
would it be false to assume that that would take care of her medical bills for the surgery?
No.
Okay.
Going back to the great bodily harm question from Judge Klein, I do want to also mention that there was a lot of emphasis on whether the culpable mental state for that could have been proved. However, leaving the scene of an accident, that statute does not prescribe a culpable mental state. So as I noted in my brief, it would have been sufficient for the state to prove recklessly, and I think that's obvious. Again, I don't think the movement has established both deficient performance and prejudice on either of those issues. Really quickly, with regard to the credibility findings, I agree with some of the statements of Judge Klein today that while the court did mention that they were officers of the court, he did also contextually say, but I've also heard nothing that makes me believe that there's been anything less than truthful, but was able to pinpoint certain things that were inconsistent and even contradictory evidence to what movement testified to. I would just quickly note, however, that if the court does have concerns with what was considered there, and I don't think, even if the judge could have possibly considered things outside the realm, he did also make findings that were appropriate, but in the event that this court decides that the credibility findings were somehow in error, I would point to the Smith case, 308 Can 778. In that case, a district court made several credibility findings based on both in-court observations and the testimony, but also appeared to improperly consider a few items. And in that case, our Supreme Court remanded the matter for new credibility findings, which would be an alternative option here. But I, again, don't think that that's necessary for multiple reasons. One, I don't think she has met her burden of establishing deficient performance and prejudice. But also, as I mentioned in my brief, I believe this court could also find the district court was right for the wrong reason. And the state is aware of the recent Supreme Court opinion regarding the cross-appeal requirement from December, and acknowledges that no cross-appeal was filed here. However, the cross-appeal requirement has not done away with this court's ability to find the district court right for the wrong reasons, especially where the question is compliance with the statute. This is best illustrated by the Ward case from 2023, where our Supreme Court indicated that it didn't matter that timeliness had not previously been raised with regard to a motion to withdraw plea, because the statute has procedural bars, and the threshold question is always whether the motion complies with the statute and its procedural requirements. The question here, all from the start, was we had a conclusory timely motion. So, but this court in the Booker case, since this case was decided, the Booker case came out and clearly indicates that you can't file a conclusory motion and try to later attach or toll the time period in order to try to improve upon that conclusory filing. In addition, the main cross-appeal case, the Cook v. Gillespie case, also notes that an appellee may brief matters for affirming the district court if those matters were raised below but unaddressed by the district court. And I would note that the district court never addressed whether the motion, the initial timely motion, was conclusory. So I believe that this court can find that the timely pro se motion failed to comply with the statute because it was conclusory, and that all subsequent filings were untimely with no manifest injustice established and no anchors to relate back to, and still affirm for different reasons if the court disagrees with the state that movement hasn't met her burden. Either way, the state asks that this court affirm the district court below, and I am out of time. So unless there are further questions, thank you for your time.
Thank you. All right, counsel, as we get that clock set for you, you have 5 minutes.
Thank you, Your Honor. I wanted to start maybe right there where we left off. In my reply brief, I cited the Lumry case for the proposition that right for the wrong reason is for those issues that were never addressed by the district court. Here, the state filed a memorandum or a motion to reconsider the judge's ruling, finding that we should have an evidentiary hearing, that the subsequent 1507 that I filed related back under the relation back rule, and the state did not appeal that decision. He denied their motion to reconsider. So the issue was raised below. The judge denied it. They didn't file a cross appeal, and the right for the wrong reason rationale does not allow this court to find this alternative basis to affirm the trial court. Just on the, and there were questions or the argument was made that there has to be some showing that a lesser included offense, for instance, on the ag battery, would have been successful. And I guess in this context, successful, I'm not exactly sure what that means, other than that there is certainly a possibility, and I'm basing this on Tucker and McCoy, neither of which Mr. Landis could remember, whether he even remembered those or even discussed them with Ms. Heinzman. Both of those, McCoy, the jury actually convicted on the misdemeanor reckless battery. And Tucker certainly stands for the proposition that under the facts of that particular case, they reversed and said these are legally and factually appropriate. And the facts in Tucker are remarkably close to this case. The officer in Tucker had a fractured wrist. Her wrist was, she had a cast on it, I think, for 5 to 6 weeks. She had to go to physical therapy. So, but even so, even on the issue of great bodily harm, which I know goes to count 2 here, the Tucker court said that's a question of fact for the jury. A judge can't make that call. So I think Tucker, the holding in Tucker, the holding in McCoy, certainly stand for the proposition that there's certainly a reasonable possibility or probability that those lessers could have been given under the facts of this particular case. One thing I did want to discuss was the error in sentencing here, or the misadvice about sentencing. In this case, again, there was a misadvisement as to what her proper criminal history was going to be. That was in the plea agreement. I think said F. Ultimately, it was E. But I think at a more fundamental level, Mr. Landis testified that she could receive a concurrent sentence.
Could and almost certainly would, I believe was his testimony is what he told her, correct?
He did say
Could and
that.
almost certainly would run consecutive.
That's
Why
correct.
is that not an accurate representation of the situation
Because-
that she faced? Because almost certainly would, yes, we've got this rule, but if we show manifest injustice, then it wouldn't apply.
Right, but this court in Wilkerson said the manifest injustice finding is almost insurmountable. And the acknowledgement form, which the state's attorney went over with Ms. Heinzman when she was on the stand, it says you could receive concurrent sentences and you could receive consecutive sentences. But we all know, based on that manifest injustice standard, it was essentially an impossibility that she was going to get 92 months.
So then why doesn't the phrasing almost certainly would equate to the situation she was facing?
Well, I think that's what he thought that the court would end up at. He also told her, the state's going to ask for this, we're going to ask for this, and the judge will go somewhere in between. Well, that's not accurate either. The judge, again, based on the manifest injustice, or I'm
That's what
sorry,
your
based on the
client
mandatory.
testified.
I'm sorry,
That's what your client testified she was told,
correct.
that there would be some midline.
That's correct. She did. Again, I'm running, I know, short on time, but I would just ask again for all the reasons we stated here and in our brief, that this court would find both deficient performance and prejudice. I know there was an issue about prejudice, and Ms. Heinzman was very clear on several occasions that had she known about the lessers, had she known about all of what we would have went over, she would have insisted on going to trial. She also said, I didn't want to sign that plea, and Mr. Landis agreed. When the state recalled him, he said yes. She said, I don't want to sign it. So there certainly was agreement there.
And she's aware that there's this serious and strong media coverage of this case. She would still want to go to trial. And she would,
I mean, that was her
I mean,
testimony.
that's the part that I don't think has been identified here. So this was a very high-profile media case. And so she would still want to go to trial with all that publicity that she had run over a police officer.
That was her testimony, and again, I mean, we didn't get into, there's certainly avenues available if the prejudice in the community is enough, you could do a motion for venue or change of venue or what have you. But that was her testimony. I mean, had she known the evidence and the officer's injury, I'm not diminishing that in any way, but her surgery was elective. There was no, I mean, that record below is clear. That was an elective surgery. It was not something that she had necessarily had to do. It was an elective surgery. But had she known all that, all the evidence, yes, she testified absolutely that she would have gone to trial. And we believe that meets the prejudice problem. We'd ask for the district court below to be reversed.
Thank you. We appreciate parties' argument, and we will see. Take this matter under advisement.